Good afternoon, everyone. Thank you for joining us. My name is Miriam Heyman, and I am joined by Dr. Robyn Powell, Ron Ayler, and Alex Dutton. And our webinar this afternoon is entitled The Experiences of Parents with Psychiatric Disabilities with Child Welfare Involvement, Perspectives from Staff Providing Legal Services. And I'll pause for just a minute while the Zoom room fills up. Next slide, please. We have American Sign Language interpretation available. To access the interpretation, click on the globe at the bottom of your screen, and then click on American Sign Language. Next slide. We also have closed captioning available. You can click on the closed captioning icon at the bottom of your screen. And on the right of your screen, the picture shows how to access the Q&A function, which we'll use at the end of the presentation. Next slide, please. This webinar and the study that it describes is funded by Ayler, the National Institute on Disability, Independent Living, and Rehabilitation Research. But the content is solely the responsibility of the presenters and does not necessarily reflect Ayler. Next slide. The webinar is brought to you by the National Research Center for Parents with Disabilities. We are a cross-disability initiative guided by the ethos of the disability community, nothing about us without us. Through services, research, and advocacy, the center provides information and support for parents with disabilities and their families. And the center is part of the Lurie Institute for Disability Policy at Brandeis University and is supported by Ayler. We're joined by our colleagues from CLS, and I'll ask Ron to say a few words about community legal services.
Alex and I are from Community Legal Services. I'm a social worker. Alex is an attorney here. We work in the Family Advocacy Unit here in Philadelphia. We represent parents that are what we call DHS involved, or CUA is our term for the agencies that provide the child welfare services. In addition to our Family Advocacy Unit, we have a number of other units like housing and utilities, and I'm going to go over a little bit further down the line just why that is so important when working with parents with psychiatric disabilities. Oh, and we have an interdisciplinary model. So every client gets a lawyer. Some clients get social workers. We also have what we call peer parents, who are people that have been directly impacted by the system as a parent. And we sort of figure out case to case through consults about which clients would find a peer parent helpful or a social worker helpful. And we kind of make those decisions, like I said, client by client.
Thank you. Next slide, please. A note about language: we acknowledge the diversity when we talk about parents of gender identity, sexual orientation, and gender expression, and we strive to be as inclusive as possible. My name is Miriam. I'm a senior research associate at the Lurie Institute for Disability Policy. My co-presenters today are Dr. Robyn Powell, Associate Professor of Law at the University of Oklahoma, Ron Ayler, and Alex Dutton from the Family Advocacy Unit at Community Legal Services. Our agenda for today will provide some background information about parents with psychiatric disabilities and child welfare involvement. I'll talk a little bit about the current study, which explored the experiences of parents receiving services from Community Legal Services in Philadelphia. And then most of our time together this afternoon will be a discussion with Ron and Alex, moderated by Robyn. And I will turn it over to Robyn now for the background portion.
Thank you. So just to give you a little background information on the population that we're talking about, we know that parents who have mental health or psychiatric disabilities represent a significant part of the parent population in the United States. Research shows that about 3.8% of parents in the US have a serious mental illness, and about 12.8% have some type of mental illness. So we can see again that they are very high populations. We also know that parents with psychiatric disabilities experience really high removal rates by the child welfare system, with some estimates as high as 70 to 80%. And we also know that 19% of children in the foster care system have a parent with a disability, and that disabled parents have a 22% higher odds of having termination of parental rights. We also know from a recent study, and it's not on the slide, but that parents with mental health disabilities are 8 times more likely to have child welfare system involvement. So we can see that this population is significantly impacted, and that they do experience really pervasive inequities within the child welfare system, and that a disability of a parent is always considered in looking at the best interest of a child for both child welfare and family law cases more broadly. Next slide. Just to give you a little bit more overview on the issues. So parents with disabilities, including parents with psychiatric disabilities, experience a number of barriers, both really recurring barriers and then more systemic barriers. So about many statutes across the country, including 42 states and the District of Columbia, currently include disability as grounds for termination of parental rights. And amongst those 42 states and the DC, we know that 36 of them include psychiatric disability. We also know that parents with disabilities, especially parents with psychiatric disabilities, are disparately impacted by certain provisions of the Adoption and Safe Families Act, particularly the stringent timelines. They just don't work for parents with mental health disabilities because it can often take a long time to find appropriate services. And we know that these really strict timelines just are really a barrier for many parents with psychiatric disabilities. We also know that there is significant case law that has found that the ADA is not relevant to termination of parental rights cases. However, I will note that courts are starting to come around and recognize that, in large part, I think, because the Department of Justice has taken a very strong role in pushing for courts to recognize sort of why the ADA is relevant in these cases. We also know that parents with disabilities, especially parents who have psychiatric or intellectual disabilities, encounter a number of systemic barriers, things like barriers to legal representation, that is, having attorneys and social workers who know about their disabilities and how to adequately support them. We know that courts in general can be very inaccessible for parents with disabilities. We also know that parents with disabilities experience significant bias and speculation, assumptions that they are dangerous or unfit to care for their children. And there is really just a lack of disability awareness within the courts, within the child welfare system, and that child welfare system workers are often not trained on how to support these families. So to give you a background on sort of why we did our current study, which Miriam will be talking about in a minute, this study was actually based on an earlier study that we did with the Family Law Project, which is out of Massachusetts. It is within the Mental Health Legal Advisory Council. And we interviewed for that study 12 former clients, so 12 individuals who all had psychiatric or mental health disabilities. We know that about 59% were white and the rest were Black, Asian, or multiracial. We know that most identified as heterosexual, and we know that a significant population, about 58%, lived in pretty low poverty rates. So based on these interviews with these 12 former clients, we found a number of key findings. The first was that parents with psychiatric disabilities reported really significant challenges sort of accessing long-term, wide-ranging legal services for them. You know, a lot of the parents we spoke with talked about how their issues around parenting and threats to their parental rights were only one of the many issues that they were encountering, and that they were having trouble finding sort of lawyers that could help them sort of long-term, be able to help them along their route. So maybe they got their children back, but then they needed help further with housing and healthcare and things like that. We also know that parents with psychiatric disabilities really appreciated when their lawyers knew about their disabilities, had a good understanding of the symptoms, their medication, how it affects them. And so the parents who were happy with their legal services, really, they were happy because their lawyers had that understanding and that knowledge. They also really appreciated and hoped to have sort of comprehensive and holistic legal services from legal services organizations. They often said that they just could not get all of their legal needs met by legal services organizations, which is why they went to the Family Law Project, which again is only serves parents with mental health or psychiatric disabilities. And finally, they talked about how they needed more formal and informal community-based supports for them and their families, and that lack of access to those supports really did hinder their ability to adequately raise their children. So based on those key findings, then the parents identified 5 specific recommendations that they believed would help to improve legal services for parents like themselves. The first is that they really believed that parents with psychiatric disabilities needed to have a voice in the services they received. They said that often they didn't feel like attorneys listened to them, and so they wanted the legal services professionals to understand that they need to listen to their wants and their needs. They also really emphasized sort of the need for a continuity of services. They said that legal services for parents with psychiatric disabilities really needed to be ongoing and wide-ranging. Again, these parents often came to the Family Law Project because of custody or child welfare matters, but then it was uncovered they had a lot of other legal challenges as well. They also talked about the importance of having responsive and reflective services. That is, they wanted legal services to respond to the needs of their disabilities. And they said that that should include individuals or professionals who had lived experience. So peer support, for example, would be really useful. They also said that in order to improve legal services professionals needed to have an in-depth knowledge about their disabilities, symptoms, medications, diagnoses, etc. They really wanted legal services professionals to have that understanding. And then finally, they said the best way to improve legal services was to make sure that legal service personnel could ensure that these parents had access to community-based services and supports. Often their issues couldn't just be solved by their lawyers, and so they needed to have access to supports outside of the organization, and they wanted, they said that legal services would be improved if they had that access. Next slide. So if you are interested more on this study, we do have a report on our website, which you can read the full report, but that is really the impetus of the Community Legal Services Project, which Miriam is now going to talk about.
Thanks, Robyn. So yeah, now I'll say a few words about the project that we did with CLS, or Community Legal Services. As Robyn described, we know that stigma and discrimination pervade the experiences of parents with psychiatric disabilities within the child welfare system, often resulting in poor outcomes. So the first 2 research questions explore these experiences, and these questions focus on barriers and facilitators to the provision of supports and meaningful legal representation for parents with psychiatric disabilities with child welfare involvement. Also, given some of Robyn's previous research, which showed that the Americans with Disabilities Act is infrequently used to protect the rights of parents with disabilities with child welfare involvement, we explored how the ADA, or the Americans with Disabilities Act, impacts this process. We worked closely with Ron and his team to recruit parents and employees for interviews. Ron shared information about the study to staff during regular staff meetings, and CLS social workers shared study information with parents via email, phone, and also in-person communication. We interviewed 13 employees, including attorneys, social workers, a paralegal, and a parent peer advocate. And this reflects the CLS model that Ron mentioned, the interdisciplinary model that provides multiple forms of support, including legal services and also referrals to community resources. We interviewed 7 parents. 71% were Black, 85% were female, and all of them had incomes below the poverty line. And our interview, each interview was about 1 hour and was conducted via Zoom. So I'll briefly share the barriers and facilitators and what we learned about the ADA. Starting with barriers, barriers include poverty, as illustrated in the quote on the left of the screen from a parent. The parent shared there has to be some type of affordable housing or some type of way where people can get housing in a reasonable time frame. The sort of delays that this parent was talking about could significantly hinder or altogether prevent the reunification process, given the fact that parents are given strict 15-month timelines in which they have to meet the reunification requirements. Next slide. Barriers also include prejudice, specifically the assumption that parenting and psychiatric disability are incompatible. A staff shared the quote on the left. Normal parents don't get believed a lot with the system, but if you add a diagnosis on top of whatever the issue is, then automatically you literally see people write families off. Next slide. And the last barrier that I'll mention includes or is trauma imposed by the child's welfare system. Many employees described how parents' mental health deteriorated due to losing their children or the threat of losing their children. And as a parent shared, they broke our family up. They gave my kids a broken home. It made me depressed. I cannot sleep. Next slide. Facilitators include referrals to community resources, things like assistance finding housing, financial support, referral to therapy, and referral to substance use treatment programs. A parent shared, like, so far, if you need any utility assistance, if you're having problems with court, they help fight with you with any housing issues. Facilitators also include staff diversity, including the presence of social workers and peer advocates on the team. Staff knowledge about psychiatric disability was also seen as an asset, although many staff members welcomed the opportunity to learn more. And then finally, regarding the last research question about the ADA, lawyers mentioned associated challenges, such as fear that judges are already biased against psychiatric disabilities. So raising the ADA might heighten the impact of stigma and discrimination. Next slide. So this ends that portion of our presentation, and I will turn it over now to Robyn, who will lead a conversation with Ron and Alex.
Thank you. I think we're going to stop sharing. All right, great. And I just want to note before we start this conversation that if folks are interested in asking questions, they can put it in the Q&A box. I think there's a Q&A box. There is, and we will get to your questions. So please, participants, send your questions to us. But I'm going to start with a few questions. So the first one is, how do you believe attorneys and social workers and advocates can effectively represent parents who have psychiatric disabilities?
Go ahead, Ron.
So speaking as a social worker, for the other social workers on the call, this is going to sound pretty familiar. One of the things that a social worker on the interdisciplinary team has to do sometimes. Alex also has his MSW, but he definitely goes into lawyer mode and might forget some of these things. But I think it's especially important to remember that physical safety and predictability are some things that a lot of our clients don't have. And if you can provide that to them, it can really improve outcomes. So things like physical safety, removing your conversation from the middle of the waiting area, right? It's a pretty simple thing. Stress tends to exacerbate any sort of behaviors we might see that are at all related to a psychiatric disability. So removing those stressors can go a long way. Predictability is another one. Just making sure your client knows who's in the courtroom, who's going to be there, what they're probably going to say. Is for social workers. For us, we do a lot of out-of-court advocacy. So it's like, I know this facilitator, here's the way that they behave. So please, try to remain calm. If you have any question, just like text me and I'll make sure it gets said. Those sort of simple things that can be very important. I think taking the time to build rapport is something I know I forget about, and kind of just making an assumption that if I'm asking a question, my client is comfortable enough to answer me honestly. So just really taking that time to build a relationship and understanding that, I mean, unfortunately, once someone's court involved, it's probably going to be a little bit of a long-term relationship anyways. So taking the long view. I think having information about how the diagnosis and how that can be sort of expected to manifest in behaviors is pretty important. But I would say you always have to remain person-centered. Every person is different, regardless of if they have the same diagnosis. And just because someone has like schizophrenia diagnosis, I mean, it might not even be an accurate diagnosis. So just remembering that no parent is perfect is another thing. And I think shifting the way other people talk about parents to, instead of having a conversation about what the parent needs to do to be a good parent, and shifting that framework, Alex is really good at it, to actually just to say, no, give me evidence that she's not a good parent, right? Like move from proving parenting to forcing the government to actually put on a case. And then the only other thing is just this family regulation system is extremely stressful. It's extremely stressful just to go to court as a social worker. I can't imagine as a parent and having to relive the trauma of somebody who's taken your child away. And just remember how stress affects behavior and exacerbates sort of everything. So those are like my main ones. Alex, what do you think?
Yeah, I think there was a request in the Q&A just to repeat the question, Robyn.
Yeah, so the question was then, how can attorneys and social workers and advocates effectively represent parents who have psychiatric disabilities?
And I think this is our sort of our broadest question, but to add on briefly to Ron's point, the answer is that it's extremely challenging, as is representing anybody in a case like this. We at CLS, you've sort of heard this, have a interdisciplinary model in which we pair attorneys with social workers and peer parent advocates who have experienced the family regulation system firsthand. And I think it sort of starts there. I think it's very hard to effectively represent a parent, let alone a parent with additional challenges like a psychiatric disability, in a system that's as degrading as this one by yourself. And that may not be a sufficient answer to many folks who bravely go out there and do this on their own every single day. But in addition to the more specific case or fact, in case specific strategies that Ron mentioned, I think that I do like to call out the institutional commitment to pairing experts in various ways, not just attorney with the attorney. So that's one thing. And then I think the other sort of bigger point that I would flag here is working on developing the rapport with your client, and that includes the attorney as well, and understanding with your client the nature of their feelings about their disability and how much they want to make it part of their case. And I know, Robyn, you've written quite a lot about the ADA and how it's been litigated in termination cases. And one of the things that Miriam was mentioning is that some of the attorneys are reluctant to raise that. The point I would make here, and I'm sure we'll talk about that more and specific things, but the point I will make here is that really has to be done in consultation with your client. And that's just not for like ethical reasons, it's for building that rapport and trust. And so you can help, the client can help you understand what their lives are like, and what other systems, right? That's another part, what other systems are discriminating against them or erecting barriers that make it challenging to overcome the specific need or issue in the child welfare case. And I think there was the first question, right? I think it was specific about the different populations in the two studies, but parents with psychiatric disabilities in the child welfare system are probably facing discrimination in many other ways, and it sort of doubles down as different identities intersect in different experiences. So this is certainly going to be more challenging for parents of color who are experiencing psychiatric disabilities. So that's my broad answer to the question. I'm sure we'll get into some specifics as we go.
No, thank you so much. And just to answer that question, because I see it, the question was sort of, why is there such differences with race? The Family Law Project was majority white, and the CLS project was majority non-white. And I think that's probably population also based. And also Family Law Project is not within legal services. They only take a small population. And whereas CLS, I used to work at Legal Aid, I remember it was just open more broadly. So I'm guessing you would all agree with that, but if you think there's something more to it, I'm just taking a gander at why I think there are some differences. Also, I think we had a lot of trouble with the Family Law Project recruiting, I will say. Many of the clients we sent flyers to had moved and so forth because of housing instability. So I just think there's a lot of factors that probably accounted for that. But to move on to the next question, the next question is actually a good one. So what is the role of a social worker on a multidisciplinary legal team, and how do you approach providing support for parents with psychiatric disabilities?
So my stock answer for that is, like, the social worker is basically sort of an interpreter between a lawyer and a client. Peer parents do a lot of the same thing, and really acting as a go-between to help, for instance, a lawyer understand why their client is not taking their recommended advice and doing what, the bright, smart lawyer knows what will quote unquote win a case. And also helping the clients understand why Alex is asking them to do that. So it's sort of like a buffer between the law and the realities of clients. That's my short answer. I don't know, Alex, do you have any other thoughts on that?
One thing, I mean, I think that what our social workers do as parent defense social workers is what I'll call them, who work in our office, and folks who work in similar offices across the country, that's unique to maybe what other social workers are doing in different sort of settings, is providing emotional support. So and that's in line with what Ron was describing as sort of being the go-between between the client and the attorney. But I think, attorneys are trained to give advice, understand the law, give advice, and sometimes that can be cold, hard advice that a parent with a psychiatric disability might not want to hear. And so one of the things that social workers do is help, and this is a long process, but help folks understand what's going on in their lives and how that relates to their case and how that relates to their desire to fight for reunification with their children or fight to prevent family separation, why that matters so much to them, and then addressing some of the other issues in their lives. And that's not to say the attorney should only be giving cold, hard advice. It's certainly there are different strategies for that, and I do think, I mean, as an attorney, I certainly never end there, right? I'm developing rapport. I'm working to understand people's lives and helping me understand what they're going through so that they can feel a participatory role in their defense. And I think that sort of goes to one of the questions in the Q&A about folks sort of being in denial about symptoms and refusing to receive care. And I think that's really where the role of a social worker is most important, in understanding what those barriers are, and why. And maybe there's a very good reason for why folks don't want to follow treatment plans that are prescribed to them by somebody, and there may be valid reasons for that, and we'll explore that with them. Or there may be not, and we'll explore what's those thought processes over a period of time. And that's really not something you're trained to do in law school. And that's where I find that the social workers are most important. But it's also, as a parent defense lawyer, that's required as well of you, even if you didn't learn it in law school. So I think that's how I would respond to that, just in conjunction with Ron's answer.
Thank you. The next question then is, how do you think attorneys can educate the courts about parents with psychiatric disabilities?
So for me, it's not necessarily the courts, but like the other so-called professionals on the case and our co-workers and case managers. The support that I provide with when a client has psychiatric disabilities really relates to education. A lot of it is normalizing behaviors that people might find uncomfortable, or just for instance, I have a client, actually Alex and I had this client or worked with this client who would send very disorganized emails overnight. Just very long, kind of rambling, disorganized emails. And Alex would try to figure out exactly what the client wanted in that situation. And I said, Alex, she's stressed out. She just needs to kind of like vent and normalize that. Like when we finally talked to her about it, she related like she couldn't sleep because she wanted her kids home, and that was the worst part of the experience for her. Time-wise was just overnight because her kids were not in her house. So she got very stressed and she would just send an email. So being able to normalize that as a social worker, I feel like can be very useful. Disputing diagnoses, I don't know about other localities, but in Philadelphia, I've seen somebody diagnosed with schizophrenia and immediately knew I'm not a psychiatrist and there's no way that this is schizophrenia. So just being able to talk the social worker language and throw the DSM-5 in there and dispute like the behavior you're seeing is not being accurately recorded in this diagnosis. So that's another way to educate other people. I would say also like just some education about, for instance, overdiagnosis of Black parents for schizophrenia. Like there's research out there that this is a big problem specifically for schizophrenia. I'm sure it's for other things as well, but just being able to make sure people understand, again, to question the diagnosis and make sure it's accurate, make sure it was well done, and it wasn't just 5 minutes with a psychiatrist in a closet office. The other one we see a lot are young people getting diagnosed at like 19. And then the petition filing says, just a side note, this 35-year-old father had a diagnosis of schizophrenia at 19. And being able to talk with people about how we should rethink that and not just trust that whatever diagnosis was made is accurate. The other big thing, and Alex, I'm sure has a bunch of these, but when our clients have a diagnosis, every parenting decision seems to be related by other people to that diagnosis. And there's this thought that like, if anything goes wrong, right, it's because there's a diagnosis of schizophrenia, and not there's like less of a recognition that sometimes kids are just fussy. And if the kid doesn't run and jump into the parent's arms like that, sometimes kids do that. It's not related to any mental health issue or psychiatric diagnosis. So those are the big ones that I have for like education wise.
And just on a strategic point, Ron sort of mentioned this at the beginning, but a lot of times we think, how do we convince that judge who I know is already biased towards my client, or I've been in front of that judge before, and there's stigma associated with that judge and how they treat people who appear before them. But there's also being an attorney is a practice in storytelling, and there's other people who can tell those stories. And one of those people is your client. And your client's an expert on their own lives and can articulate if the circumstances call for it, what's going on, in a way that we often can't do and probably never can do. And then there's also people who tell the story on behalf of your clients. So I'm sure everyone's familiar with how these cases work. The caseworker goes in and they testify about what's going on in the case, why the case got opened, or what the efforts have been made towards quote unquote permanency or reunification. And so it's working with those case workers to help be conduits for that storytelling, and that's out of court negotiation, but it's also sort of peeling back the layers and helping people understand what our clients' lives are. And some of that, I have to admit, some of that, I go into a lot of meetings, I go into a lot of court proceedings, like ready to push back, right? And that can look adversarial at times, but then so we have to take ourselves out of it a little bit and focus on that storytelling part of it. But at the end of the day, when we do have to fight back, we will fight back and make those arguments before the court, present evidence, present expert testimony if it's required, right? If the adverse witnesses aren't willing to understand what's going on with your clients, as is often the case, potentially peeling or enlisting other folks who do, including treating professionals who actually know your client, and getting to know them and understand what your role is as their attorney or their social worker, and how they can be part of that storytelling process for the court, but also expert witnesses who can testify about the stigma and the ability of parents with psychiatric disabilities to be able to parent at home successfully, and challenging really cheap and unprofessional evaluations of our clients, and stigma associated with those as well. And that requires investigation, and it requires potentially motions to the court for expert witness fees and things like that. So there are a number of different strategies that attorneys can use as well.
Thank you. We have tons of questions, so I'm going to jump into some of the questions before I go. If we have time, we'll go to the last one, but I want to make sure we have time to answer these questions. So the first question is from someone who has a client with autism, and DHS, I assume that's child welfare system, took custody for lack of parenting skills. She has taken all the classes that's been recommended, and her parenting skills are improving, but not to where the agency wants them. She has no family or support. And sort of the question is then, where is a good place to turn for live-in help? Any thoughts?
So in Philadelphia, I would immediately try to maximize whatever services would be available through the autism services here in Philadelphia. I think the other thing with that, I think it would be specific to whatever the locale is. But I think the other part of that question that I just want to kind of address, as it gets to what I was saying before, is getting some evidence that the parenting still has a deficit, right? Like, to me, if the client is doing everything you ask them to do, but you're still not returning their child, then you're not asking the right things, and that's actually on the social worker. That's not on the parent. I mean, it obviously has much larger effects on the parent than the social worker, but that would be another thing that I think I would bring up, and I'm sure Alex would bring that up.
Yeah, I would certainly challenge the conclusion and the evidence supporting the conclusion that your parent or your client is not able to provide the standard of parenting that's required by law. And then you can get creative with the ADA as well and make affirmative motions, or make motions or file ADA complaints outside of court, and seek either through like OCR or affirmative litigation that way. And Robyn sort of mentioned that there have been some bad decisions, but maybe it's a changing tide in the state of case law with respect to the ADA as it relates to termination of parental rights. But it doesn't mean that you can't be creative and seeking reasonable accommodations. I can't answer the specific question about live-in help without knowing more details, and the locale, of course, and probably not familiar with your area, but and that's challenging. But I would question the need for live-in help in the first place, of course. But and then thinking like, okay, well, if you can't do that, what challenges can you make to get reasonable accommodations, or to challenge the the agency's decision making or the judge's decision making through other venues like OCR for ADA complaints, which have been successful in the child welfare realm.
Right, that we've seen increasing, I think, involvement from HHS's Office for Civil Rights and DOJ. So I think there has been some success. So the next question is sort of something you've already both touched on a little bit, but how can attorneys best represent parents with psychiatric disabilities if the primary concern is the parent's denial of any psychiatric symptoms and their refusal to receive care?
Ron, I think I touched on this earlier. I think one of the things, relates exactly to the last point we were making, and questioning the assumption that a parent's psychiatric disability means that they're not able to provide the requisite level of parenting, or that they're somehow providing negligent parenting, right? Now, of course, if you're in the point of a case where there's already been a decision about that, then the calculus is different. But challenging these ideas and these stigmas up front, and requiring the government to establish that not just is there a psychiatric disability, but there's a nexus between that person's psychiatric disability and their ability to parent, and take care of all the things that the law may require a parent to do in a particular state. And that's something that came up in the project. And as Miriam pointed out, it's some of the attorneys responding with a little bit of fear about, do I bring my client's disability into the case? Or if they're attempting to bring, the agency or the government's attempting to bring my client's disability into the case, do I fight against that? And there are ways to do that. In Pennsylvania, like an external diagnosis by someone else is hearsay. So you can challenge those things under evidentiary rules. And we've been successful doing that, where agencies wanted to make our clients, wanted to make the disability the crux of the case by just screaming the diagnosis without any evidence that there was a nexus to their parenting. And we challenged the diagnosis and successfully did so without even getting to the question of whether there's a nexus. And of course, we do those causation defenses as well. And again, you do that in consultation with your client. Some clients go the other direction and they're really kind of open about it and aren't comfortable with that kind of defense. And that's where the social work team comes in, and we can talk those things through with our clients. And then we're thinking about, okay, what are the accommodations that would benefit you, and how we move this thing forward. And I think a lot of this also depends, and the reality of this work is, what kind of caseworker or investigator do you have on your case? What kind of judge do you have on your case? In most of these, and in Pennsylvania, they're all bench trials. There's no right to a jury. But who are the people that you have to convince? Who are the conduits for your storytelling? And are they sympathetic in various ways? And that can change the calculus for a client as well. And that's our jobs as attorneys, to advise them in consultation with our interdisciplinary team.
Thank you. So I want to ask, this is an interesting question that I get a lot, so I'd love your thoughts. In dependency cases where an attorney determines that clients cannot direct them in their defense, or that they're not able to understand the context of the dependency process, will you substitute judgment, seek a guardian ad litem, or what else can be done?
I suppose that can happen. I've never had to do that in my career. And I suppose that can happen. And there are procedures in every jurisdiction for making that kind of a motion. But I'm certainly not an expert on that. I haven't had to do that in my career. And that's a little bit beyond, I think, the presentation.
Yeah, I will say, though, I asked only because I get that question a lot. I mean, I think I would remind folks, I teach professional responsibility, and you do have a duty to sort of engage in the most quote unquote normal attorney-client relationship that you can. So, and the only hesitation I would say is, if you bring in a GAL, you should assume the judge is going to see that person as incompetent, because that is essentially what you're saying. And so I think there are some concerns. I was speaking with a lawyer last week, and she was co-counseling and the other lawyer wanted to bring in a GAL. And the issue was that the parent couldn't understand sort of who was testifying and who was representing her and who was representing the state. And that lawyer just took a piece of paper and drew it out, and the parent understood it. And so the parent almost had a GAL for no reason, really, other than it took a 5-minute sketch to answer the problem.
Yeah, I think there's a lot of strategies that you can use before you would ever get to that point, which is sort of what I was getting at in terms of not having to have to do that. It took me a long time to understand who all the different people were in a courtroom after graduating from law school. So,
right. So another question is, can you give some examples of accommodations that you've requested from child welfare on behalf of parents?
Certainly, transportation accommodations for everything from visits to services, housing services, and some accommodations for participating in evaluations in themselves to make sure that they're accessible. And if folks have limitations around participating in those evaluations, that's something that could be very hard and could lead to bad evidence if accommodations are not provided, especially around questions of capacity to parent, these sort of psychological determination evaluations, and then certainly therapeutic visitation, where there may be, like, I've had cases with, as kids get older, with folks with psychiatric disabilities, having some questions about what's going on with their parents, and parents may have done, like, everything on paper that to do, and then kids are sort of like trying to understand their parents. And I think therapeutic visitation as a way to help parents help children understand their parents and help parents respond to maybe their children's behavior, not just accepting that, well, the visits happen, but the visits don't go well, and, well, they don't go well because of this or that. It's like, okay, what other interventions can we try? And there's certainly other accommodations in that sense. Those are just a few off the top of my head.
Yeah, I think not necessarily accommodations, but there are some services in Philadelphia that we just know are better for parents with psychiatric disabilities, just through our experience of having worked with them and knowing how they treat our clients and knowing that they have understanding. So I guess it's not technically an accommodation, but making sure the client or the parents get referred to those particular services that are actually more successful, rather than just a cookie cutter approach to case planning.
And one thing, this isn't a direct response to the, what reasonable accommodations have you requested or received or secured for your clients, but to the original, one of the points that, I don't know if it was Robyn or Miriam mentioned, but something that came out in, I suppose it was Miriam, because it was our project, just like housing, for example, being such a huge barrier, all these other structural factors that exacerbate the symptoms of people's psychiatric disabilities. And so making sure you're securing all of those services through court orders that you can, and other sort of public offerings that you can for your clients. And also supporting them as they fight to reunify with their children. That's the biggest trigger of their psychiatric symptoms, is not being with their kids. So there's that as well.
Thank you. The next question then is sort of a good one. How do you think peer parent advocates can best help parents with psychiatric issues?
So our peer parent advocates are superstars, and if I could figure out how they were so successful, I'd bottle it and sell it to every social work school in the country. I think there's a unique, immediate rapport when the person across the table from you has gone through something similar that you've gone through, and to me, that I've been doing this for 20 years and I still don't know how to recreate that. So I guess my answer is I don't know, but they're amazing at it.
And I would add, I think to that point, a lot of the stressors that are exacerbating symptoms are really just, I miss my child, and it pains me that I'm not here for my child, and my child can't be with me. And so having someone who has been through that and can speak to the challenges in getting up every day, for example, more so than a therapist who's treating their psychiatric symptoms could ever understand, potentially, is important.
Thank you. So the next question then is, what recommendations do you have for challenging the assertion that the Child Welfare Agency has made reasonable efforts to prevent the need for removal or mitigate the problems that led to the removal?
This is an area where you can get creative as an attorney and as a team, I would say, in thinking about what other services were available that the agency failed to consider, and then establishing a record or creating a record that failure to consider those services was unreasonable, and that there are other services available that would prevent it. The need for removal, destigmatizing, challenging the diagnosis, but also challenging the nexus between a diagnosis and a parent's ability to provide a safe place and safe home for their children. We see kids getting removed all the time that for reasons other than pure safety reasons. And if there's a immediate removal of a child legally, it should be because there's an imminent safety threat. And oftentimes it's not supported with causation evidence. And then potentially bringing in other people and other witnesses, both lay and expert witnesses, to either explain what other options are available for folks, including mother-baby type placements for folks with psychiatric disabilities, where folks can receive treatment and maintain their parental roles from a legal standpoint and be with their kids. And so, and making sure we have a clear understanding of what all those options are for parents in our area, and bringing those folks into court to explain to judges and caseworkers that we are available. There is space. That's one of the things we really do. And we'll have people on call, and there's space available. If this person is eligible, they have to do an intake. But yes, we're more than happy to have them come in. We have relationships with those people, and the agency will say, no, we don't believe that's appropriate because whatever. And then we bring them into court. And then the judges have to make a decision. So, and oftentimes when people are there in court saying, we will take you in and treat you, and they can stay with their children, that can be pretty powerful.
Thank you. So someone asked, what about the reasonable accommodation of more time, since this would be in conflict with the strict timelines for permanency?
So I don't know of any case that has specifically challenged the ASFA timelines. So that references to the timelines of termination for parental rights under ASFA's 15 out of 22 months timeline. I'm not aware. Maybe Robyn, you know of that there's been a challenge under the ADA to that provision, and arguing that that's a reasonable accommodation. Certainly, there's been some writing about the constitutionality of that timeline recently. So I certainly think it could be something that is raised. A lot of times litigating the accommodations throughout every single hearing, and forcing the agency to do its job and forcing the judge to consider this every single time you come into court, can push those timelines as a practical matter beyond the strict 15 months. If you're fighting every time you go into court, and you're gaining, even if it's a little bit of accommodation every single time you go in there, then maybe you don't even have to contend with that issue. Maybe you're pushing a case out till 3 or 4 years, or hopefully not. Hopefully you're achieving reunification before then, but maybe you make the timeline sort of moot in that sense. That's another thought, in addition to like a direct challenge that their intention.
Yeah, I mean, I don't know of any cases off the top of my head, but I know that there are cases that have said essentially that if a state did not provide reasonable accommodations, then their efforts weren't reasonable. And we know that in ASPA, there is a provision within that timeline piece that says that if someone has not received reasonable efforts, then the timeline can sort of be extended. So I think, I don't know of cases specifically, but I'm sure that you could make the argument. I think I'll ask one last question. We're running low on time, but so someone said each family's circumstances and resources are different. In cases where reunification is not possible, do you have any tips or strategies to maintain a parent's relationship with their children moving forward? Are there any are they different for relative or kin permanency placements versus non-family foster care adoption?
I have seen this actually, like guardianship options be available, like that agencies. This is actually in cases where I have a few cases with folks with psychiatric disabilities where they've sort of ballooned into like 3-year, 4-year cases because my client really has pushed back and successfully addressed, everything that was asked of her. But there are these lingering issues. Kids get older, and actually one of them is the example I provided earlier, where child is sort of struggling to understand what his mother's going through, and guardianship often is where we've been able to get those cases, both with kinship, so folks who the child may be placed with someone they know, but also long-term non-kinship foster care placements, and there are ways and strategies to direct those cases towards a guardianship option, which allows, at least in Pennsylvania, allows parents and attorneys for parents to advocate for pretty liberal visitation plans. And the longer those cases go on, we've worked to develop relationships between parents and the either kinship or non-kinship foster parents to help those folks understand our clients' disabilities. And that requires, a commitment, sort of reaching out across the aisle a little bit. But that's helped our clients move forward and maintain bonds with their children, even where cases end in guardianship, which also allows them to petition for custody at any point in the future. So from a legal standpoint, it tends to be a better direction.
Yeah, and I think that's one of the ways the system can improve, is to ensure that there is contact allowed or facilitated between out-of-home caregivers and parents. Because it does take a lot of time and effort to make that happen, and it really should be the default, in my opinion.
Thank you.
Thank you so much, Robyn, Ron, and Alex. We are so immensely honored to have you here with us for this conversation. I have on the screen now resources that are available on our website as well as on other websites. And I also want to point out that in the chat, there are links to 2 surveys. One is a brief satisfaction survey. We'd greatly appreciate your feedback on this webinar. And the second is a survey that you would need to fill out if you would like to receive a CEU for social workers. We're able to offer 1 CEU for your attendance at this webinar if you fill out that survey. So with that, I would encourage you to contact us. Our information is on the screen. And again, thank you so much, Ron, Robyn, and Alex. It was a wonderful conversation, and we're so appreciative of your time and expertise.